With that question in mind, let's go back to the facts of the case. The Second Amendment instructs a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. This single sentence provides us with a lofty command, but little concrete guidance. In the past 2 decades, the Supreme Court has stepped in to provide this guidance, offering a methodological framework by which to structure our inquiry. Now, here I completely disagree with the court. The Second Amendment gives concrete guidance. The right of the people to keep and bear arms shall not be infringed. That is a positive declarative statement. It doesn't get much more concrete than that. Anything that infringes on the right of the people to keep and bear arms is prohibited. Of course, I'm pretty sure the court wants some wiggle room in order to get the outcome they want. Yes, the Supreme Court has provided guidance, but that guidance seems to contradict what the Constitution actually says. This was a question we earlier faced as an en banc court in Colby. Our primary holding in that case was that the assault weapons regulated by the statute were not within the scope of the Second Amendment. Specifically, we resolved the case by finding that the covered weapons were like M16 rifles, i.e., weapons that were most useful in military service, and thus outside the ambit of the Second Amendment. It was only after we affirmed the district court's award of summary judgment in favor of the state on those grounds that we turned to finding in the alternative that assault weapons regulations survived intermediate scrutiny. This is where the court goes completely off the rails. First of all, only one of the covered weapons were anything like an M16. Second, how does the fact that a weapon is like another remove it from Second Amendment coverage? Of course, we still have this scope of the Second Amendment question. Having elucidated our understanding of the Second Amendment's text in its historical context, we turn to the Maryland regulation under challenge in this case. Our analysis confirms that the covered weapons are not within the ambit of the right to keep and bear arms as codified within the plain text of the Second Amendment. While the court may have elucidated their understanding of the Second Amendment, their understanding is not based in the law. The court provides no evidence that when the drafters or ratifiers of the Second Amendment said arms, they actually meant, well, arms that are not too scary or too dangerous. In short, their analysis is not based on the language of the Second Amendment, but on their desire to get a specific outcome.